have the great honor, unexpected honor, of introducing Mr. Eddie Tabash to you this morning. Most of you are very familiar with him. Eddie is a constitutional lawyer in this Los Angeles area. He chairs the board of directors of the Center for Inquiry, the Council for Secular Humanism, and the Committee for Secular Inquiry. He also chairs the nationwide legal committee of Americans United for separation of church and state. He has filed amicus briefs before the United States and California Supreme Courts. He is also a very well-known atheist debater, having debated such prominent religious philosophers as William Lane Craig and Richard Swinburne. Too bad I don't know how to say his name. And you can read all that in your book. But I have the great honor of telling you that he stayed at my house many years ago and played with our dog Darwin. And he has such an incredible memory that he remembered all that and reminded me of it. So I think you're in for a real treat. Listen carefully and enjoy yourselves. Thank you very much.
Well, I want to thank the American Humanist Association for inviting me to give this presentation. To my brother and sister humanists, we stand on the threshold of two possible futures. One possible future is one in which we will continue to evolve as a modern secular society where believer and non-believer are equal. The other possible future requires just a shift of one vote on the United States Supreme Court, and we will be thrust into a theocracy. Right now, in terms of preserving the separation of church and state, which means the equality of the non-believer before the law, we have 4.6 justices on the court, they have 4.4. Even if President Obama completes 3 selections to the court before he leaves office, they will be a wash. It will not be a net gain. The president elected in 2016 will be able to shape the court. Now, I'm going to present to you this morning some very remarkable history. I'm going to demonstrate to you that even though there is a sparse record from the founding era, that remarkably, even amazingly, the founders explicitly intended a constitutional scheme in which believer and non-believer would be equal before the law. The religious right and their representatives on the United States Supreme Court take the view that government is permitted to favor all religion against non-belief. And as you will soon hear, that's been refined to all monotheistic religions, as opposed to non-belief, and even as opposed to polytheistic forms of belief. And so, for us who do not believe in the supernatural to be equal before the law, we have to be sure that the president selected in 2016, selected or elected, given our history, will be one who supports the separation of church and state. Every presidential and Senate election, since the Senate has the power to accept or reject all federal court nominees, in my view, every presidential and Senate election should be about the Supreme Court. Now, many of you, after I give you the history this morning, are going to say, well, if it's that clear, why should there even be a dispute? Remember, notwithstanding the clear intent of the Constitution, in terms of practical reality, as former Chief Justice Charles Evans Hughes said in the first part of the 20th century, the United States Constitution means only what any 5 justices say it means at any given moment in time. And let us bear that in mind. Now, initially, when the 55, before I begin, I just want you to know that the outline for the historical portion of this presentation is online at the AHA website for this conference under my talk. So you'll be able to actually get your own outline of the specific historical facts, because my purpose is to arm all of you with the arguments to demonstrate that not only were we not founded as a Christian nation, we were founded so that everyone, regardless of their viewpoint on matters of religion, is equal before the law. When the 55 authors of the original Constitution gathered in 1787, they refused to pray for guidance even when their deliberations were stymied. And the legally operative provisions of the Constitution, even before the Bill of Rights, contain no mention of God. In fact, there's only one mention of religion, and that's a negative one. Article 6, Clause 3 prohibits any religious test for public office. When the nation was debating whether to ratify the Constitution, future Supreme Court Justice James Iredell, supporting the prohibition against any religious test, said that if we value religious liberty, we must allow pagans and those with no religion at all to be elected to office. The founders intended a government mandated to treat believers and non-believers equally, and this can be seen from the work of two then future presidents of the United States, Thomas Jefferson and James Madison. Madison, conferring with Jefferson, was the principal author of what was to become the Establishment Clause of the First Amendment, which prohibits any law respecting an establishment of religion. And as I will demonstrate later on, this doesn't just mean no law establishing a religion. It is no law even respecting an establishment of religion. Madison was the principal architect of the First Amendment. So his views and those of Thomas Jefferson, which were undisputedly his major influence, are the most compelling of any facet of the historical record. In 1785, 4 years before submitting the first draft of the First Amendment, Madison opposed a general assessment in his native Virginia that would have benefited all the clergy. In the 1785 Memorial and Remonstrance against religious assessments, Madison wrote, and this is the first golden nugget to demonstrate how the founder, the true author of the First Amendment, felt about Christian government. During almost 15 centuries has the legal establishment of Christianity been on trial. What have been its fruits? More or less in all places, pride and indolence in the clergy, ignorance and servility in the laity, in both superstition, bigotry, and persecution. Not even the most progressive-minded president or high-ranking political figure in the United States today would dare say something like that. Now, even more telling, in 1786, Madison secured the passage through the Virginia legislature of his and Jefferson's Virginia Statute of Religious Freedom, which shielded minority viewpoints on religion against the tyranny of the majority, protecting both non-believers and religious dissenters. And in a very, very amazing turn of events, in 1821, Jefferson, looking back in his autobiography, exulted in how Madison, acting on his behalf, in Madison's behalf, was able to defeat the effort to amend that bill to protect only Christians. And here it comes. Jefferson on his behalf and Madison's behalf said that they were delighted that the bill protected everyone, including the infidel of every denomination. Now, right after the bill's passage, Madison wrote to Jefferson in January of 1786 and said that the provisions of this law have in this country extinguished forever the ambitious hope of making laws for the human mind. Jefferson himself was a deist, not a believer in the divinity of Jesus. As most of you know, a deist is somebody who believes some mysterious entity jump-started the universe and then took an eternal coffee break. In October of 1819, in a letter to William Short, Jefferson stated that among the claims about Jesus that he rejected were the Immaculate Conception, deifying him, miraculous powers, resurrection and visible ascension, the Trinity, original sin, and atonement. But even more powerfully, in April of 1823, Thomas Jefferson, the then retired third president of the United States, wrote a letter to John Adams, the then retired second president of the United States. And Jefferson said in this letter about God, "Of the nature of this being, we know nothing." Now, in the same letter, Jefferson, the third president of the United States, said to the second president of the United States, "And the day will come when the mystical generation of Jesus, by the Supreme Being as his Father in the womb of a virgin, will be classed with the fable of the generation of Minerva from the brain of Jupiter." Now, in an even more funny way, about a year before he died, in January of 1826, Jefferson wrote to General Alexander Smith that the book of Revelation is merely the ravings of a lunatic, no more worthy or capable of explanation than the incoherence of our own nightly dreams. And remember, this was the third president of the United States. Jefferson and Madison historians assert that the two held identical views on church-state separation, and the historical record certainly bears this out. Now, what is even more amazing is that in 1787, 13 years before being elected the third president of the United States, Jefferson wrote in his Notes on Virginia, in Note 17, "The legitimate powers of government extend to such acts only as are injurious to others. But it does me no injury for my neighbor to say there are 20 gods or no God. It neither picks my pocket nor breaks my leg." Imagine anyone today with a history of having said something like that being elected to the presidency after having said that. This is truly amazing. Now, to demonstrate the antipathy that Madison and Jefferson held toward the clergy, if the clergy is imbued with political power, in his 1813 letter to Alexander von Humboldt, Jefferson writes, and he uses the term priest as a generic term to cover all clergy, "History, I believe, furnishes no example of a priest-ridden people maintaining a free civil government. This marks the lowest grade of ignorance of which their civil as well as religious leaders will always avail themselves for their own purposes." And then Jefferson wrote to Horatio Spafford, "In every country and every age, the priest has been hostile to liberty. He is always in alliance with a despot, abetting his abuses in exchange for protection of his own." And then again, 13 years before being elected President of the United States, Jefferson wrote to his nephew, Peter Carr, "Fix reason firmly in her seat. Call to her tribunal every fact, every opinion. Question with boldness even the existence of a God, because if there be one, he much prefer the homage of reason than that of blindfolded fear. Do not be frightened from the inquiry by any fear of its consequences. If it ends in the belief that there is no God, you will find incitements to virtue in the comfort and pleasantness you feel in its exercise and the love of others which it will procure you." So here he is telling his nephew that if his nephew, after a philosophical search, becomes an atheist, that it's perfectly all right. Now, in 1788, Madison, writing in Federalist Number 52, urging ratification of the Constitution, defended the prohibition against any religious test for office. Madison said that public office should be open to merit of every description without regard to any particular profession of faith. And then, just 8 months before drafting the first draft of the First Amendment, Madison, in a letter to Jefferson, expressed concern that people would deny infidels the right to hold office, and that the public, if given the chance, would substantially narrow the rights of conscience if given the chance. So, the dominant theme of the historical record is this: prior to all other considerations, as the underlying foundation of the very essence of the founders' concern was to protect the rights of conscience. You see this throughout the deliberations. What the founders were aiming at was to create a constitutional system in which each of us would be equal before the law without any government coercion to believe or not believe. And the fact that Jefferson and Madison so carefully doted on protecting the infidel shows that, without a doubt, Madison went into the drafting of the First Amendment with the desire to make sure the non-believer is equal. It was the underlying, the bedrock of the founders' intent that any American's right of conscience would extend equally to belief or non-belief, and that government should not play a coercive role in anybody's view of how the universe is put together. In June of 1789, Madison, a member of the very first Congress, proposed what was to become the First Amendment, preventing government from abridging the civil rights of anyone because of religious belief or worship, and also preventing the establishment of a national religion and preventing infringement upon the full and equal rights of conscience. Now, I just said a few moments ago that the underlying foundation of the First Amendment in terms of protecting the rights of believers and non-believers was to shield everyone, whether they believed in the supernatural or not, from any coercive force of government. This is tellingly amplified by the statement during the House debate on what was to become the First Amendment, and as sparse as the record was, we have a clear statement from Representative Daniel Carroll, who was also one of the original signers of the Constitution 2 years before. And he said on the floor of the House during the debate on the religion clauses, "The rights of conscience are in their nature of peculiar delicacy and will little bear the gentlest touch of government hand." And this shows how that theme ran consistently throughout the deliberations. Now, I told you that the religious right today and their legal scholars and their justices on the Supreme Court maintain that government must not favor one monotheistic faith over another, but can favor all monotheistic faiths against atheists and those believe in multiple deities. If that were true, what I'm about to tell you would not have happened. On September 3rd, 1789, the Senate considered two proposed wordings that would have done just that, and they were rejected. So if, in fact, the religious right is correct, that the First Amendment was meant only to prevent bodies of government from favoring one monotheistic belief over the other, but that all of them could come together as a monolithic opponent of non-belief, these two proposed wordings would have been accepted and not rejected. One proposed wording provided no law establishing one religious sect or society in preference to any other. The second rejected proposed wording was no law establishing any particular denomination or religion in preference to any other. So clearly, the religious right and their allies on the Supreme Court are claiming that the Establishment Clause meant what was rejected twice in September of 1789. And then in September of 1789, Madison chaired a joint conference committee and came up with no law respecting an establishment of religion or prohibiting the free exercise thereof. No law even respecting an establishment of religion is much broader and more sweeping than no law preferring one religious sect over the other. It was a blanket prohibition. Now, since Madison was the initial architect of the First Amendment and Jefferson was his main influence, the commentary of both of them, even after the First Amendment, is relevant to what was on Madison's mind when he, with Jefferson's influence, was shepherding it through Congress. Jefferson, as president, writing in 1802, said that the effect was to build a wall of separation between church and state. Madison was so concerned about the accumulation of power by religious institutions, he even had misgivings about religious organizations holding property. Jefferson, as president, refused to issue Thanksgiving proclamations because he felt such proclamations were religious exercises. When have we seen in modern times a president who will not issue a Thanksgiving proclamation because that president believes that to do so would be a religious exercise that is improper for a president to engage in? This is absolutely amazing. Also, Madison, as set forth in his detached memorandum of 1817, wanted to limit the power of religious entities to accumulate and to hold property. And Madison, the fourth president of the United States and the principal architect of the First Amendment, opposed exemptions, tax exemptions, for property already owned by religious institutions. Now, this is really, really incredible. If Madison were around today, some of our organizations would say, is he too radical? Can we still have him speak at our convention? Does he go too far? This is incredible. And I just want to, because I'm trying to arm you with the true meaning of the separation of church and state, I want to address briefly the free exercise clause, not prohibiting the free exercise of religion. There are even some people who should know better, who are otherwise supportive of church-state separation, who believe that religions, or particularly religious minorities, should have special rights to dodge the application of laws that apply to everybody else. But this would allow the free exercise clause to swallow up the establishment clause. So there is a way out, and it's not that complicated. It is to view the free exercise clause as a shield and not a sword, and to view it as protecting the religious from discrimination peculiarly unique to them, but not as an avenue of giving any religious person special rights. So, for instance, if there's a law that says, as the Smith case decided by the Supreme Court in 1990, that many liberals decried, but I felt was the right decision under the Establishment Clause, that members of a Native American religion could not be able to have special exemption from Oregon's laws against smoking peyote. Well, to me, either everybody can smoke peyote, but if you only give an exemption to persons who subscribe to a particular religious belief system, you are giving the religious rights no one else has, and that violates the Establishment Clause. Another analogy would be this. If, let's say, a public high school permits students to be exempt from dissecting animals in zoology class only if they have a religious scruple against dissection, but will not grant a similar exemption to those with a secular philosophical aversion that would violate the Establishment Clause. Any time any member of any religion has a right that a non-religious person would not have under the law to avoid abiding by laws that should apply to all of us, there is a violation. So how does the free exercise clause work? Well, there is a case where I think all of us who believe in church-state separation should support the majority decision, because here it was not giving a religion special privileges. It was making sure that a specific religion didn't suffer discrimination that nobody else suffered, which is not a threat to us. In the Church of Lukumi I Babalu, a Santeria church, versus Hialeah, Florida, the city of Hialeah, Florida passed a law saying you can kill animals for any reason and even no reason, but you can't kill them for the purpose of religious animal sacrifice, because the Santerias like to sacrifice chickens and things like that. Well, if you can kill an animal for any reason, and the only reason you can't is for a religious reason, then that is an invidious discrimination against a religion. So it is not giving a special privilege to the religious. It's giving them less rights than anybody else. So what we need to bear in mind, and we need to tell our very religious society, is we are not out to have the religious suffer lesser rights. We just want to be fully equal. As I said to the United States Supreme Court in my brief in Mike Newdow's pledge case, we church-state separationists would equally oppose a phrase in the Pledge of Allegiance that said, "One nation under no God." We want it silent so all of us can have ownership of it. So I needed to clarify that in case a religious person or even a misguided civil libertarian tries to use the free exercise clause to challenge our views on the Establishment Clause. And it wasn't until 1947 in Everson versus Board of Education that the United States Supreme Court finally recognized what the Establishment Clause said, and in the majority opinion by Justice Black, it said no branch of government can favor belief over non-belief, no branch of government can favor one religion over others, no branch of government can favor religion over irreligion. And the phrase, no branch of government can favor religion over irreligion, hangs by a thread of one justice. And if the next President of the United States is able to give the religious right a 5-vote majority on the court, for the first time ever, the court will be poised to rule that government can favor religion over irreligion, and then it's open season on the civil rights of the non-believer. Now, it's true that when the First Amendment and the Bill of Rights were enacted, they restrained only the federal government. However, after the Civil War, when the 14th Amendment was ratified in 1868, it incorporated to the states all the protections of the Bill of Rights. And it couldn't be anything else. Imagine if the First Amendment were not incorporated to the states, and even though the federal government couldn't arrest us for what we say, the government of each state could. It would be an impossible constitutional system. We've always had religious fundamentalism, but the infusion of a powerful religious fundamentalist force didn't come about in American politics until the 1980 elections. And I just want to give you some of the history of the past 33 years. They arose with Ronald Reagan's campaign in 1980, where he began campaigning directly to primarily Protestant evangelicals. Then, in March of 1982, President Reagan said to the Alabama legislature, "Sometimes I can't help but feel that the First Amendment is being turned on its head. The First Amendment was not written to protect the people of this country from religious values. It was written to protect religious values from government tyranny." Well, if we're not to be protected from religious values, how far can the legislature go in imposing religion on us? And then, in his re-election year in 1984, President Reagan said, "America needs God more than God needs America. If we ever forget that we are one nation under God, then we will be a nation gone under." If that is official public policy, what is the role of and the equality chances for the non-believer? The Texas Republican Party platform in 2004 reaffirmed the United States as a Christian nation and called church-state separation a myth and called for abstinence only instead of sex education. While visiting with the Pope in 2004, in his re-election year, Bush asked the Vatican to push American bishops to be more aggressive in religious issues like abortion and banning same-sex marriage. In Lancaster, Pennsylvania, President Bush told an Amish crowd in his re-election year of 2004, "I trust that God speaks through me. Without that, I couldn't do my job." Maybe the fact that he thought he was channeling might explain some of the things that came out of his mouth during those 8 years. We all know this, but it bears repeating. If we lose government neutrality on matters of religion, we will face government efforts to control issues of birth, life, death, sex, health, marriage, medicine, and the role of the family. Not only, as we've seen in last year's presidential campaign and the attack on the rights of contraception by the Catholic bishops, not only would we lose abortion rights, even contraception and access to contraception would be in jeopardy. Because Pat Robertson, the leading Christian extremist who's had the most influence on Presidents Reagan, Bush, and Bush on federal judicial nominations, opposed the 1965 case of Griswold versus Connecticut, which said that the state could not ban birth control even among people married to each other. Robert Bork, who Reagan almost put on the Supreme Court and we were able to defeat in 1987, said there's no right of privacy, and the Griswold case was wrongly decided. But more chillingly, Bork took the position that the free speech clause of the First Amendment doesn't protect anything we say outside of a political campaign. And these are the people that talk about limited government. Jerry Falwell, before his death, one of the leading lights of the religious right, wrote in America Can Be Saved, "I hope I will see the day when, as in the early days of our country, we won't have any public schools. The churches will have taken them over, and the Christians will be running them." We are honored, of course, to have in the audience today Dr. Richard Dawkins, and since he is one of the premier defenders of evolution, all we have to do is look at the threat to the scientific teaching of evolution in our public school system, whether it is through direct creationism or through the Trojan horse of intelligent design. We can see what will happen. And we can also see what would happen if there were a fifth vote, which is all they would need to allow creationism and intelligent design to be taught in the public schools. But this extends even to global economic competitiveness, because the banning by President Bush of stem cell research in May of 2001 has put us behind in modern biotechnologies. The notion that a soul enters a fertilized egg is a purely religious one. And again, the separation of church and state means also this: no law can be based on religion. Now, if there's a religious argument, but the law can stand on its own on a secular basis, it can still stand. But if the only way a law can survive is by the inclusion of a religious justification, it's unconstitutional if we apply the Establishment Clause properly. So here's an example. Every minister in a town says you shouldn't be able to drive 100 miles per hour in a school zone. Well, that doesn't matter because there is such an independent secular ground for that prohibition that it's clearly not a religious enactment, even though religious people support it. But to say that a soul enters a fertilized egg, or that persons of the same gender should not be able to marry, is grounded purely in religious dogma, and any laws derived from that are unconstitutional. Now, speaking of the LGBT rights, not only would we lose the right of same-sex marriage for persons who choose to marry someone of the same gender, there would also be a recriminalization of the right of persons of the same gender to physically make love with each other. In 1990, in his heyday, Pat Robertson on his 700 Club, at the time when he was influencing the first George Bush on judicial nomination, said, "Many involved with Hitler were Satanists, many were homosexual. The two things seemed to go together." But even in a much more ominous way, the former and unfortunately current Chief Justice of the Alabama Supreme Court, writing a concurring opinion in a decision denying custody to a lesbian mother, said this, and remember, even though it's Alabama, this is the Chief Justice of one of our 50 state Supreme Courts, re-elected last year. "Homosexuality is against both natural and revealed law, a detestable and abominable sin. The state carries the power of the sword, that is, the power to prohibit conduct with physical penalties such as confinement and even execution. It must use that power to prevent the subversion of children toward this lifestyle." What is the Chief Justice of any state Supreme Court doing? Using the word execution and revealed truth and sin in any kind of legal opinion. This is very, very frightening. And as far as sex education is concerned, the abstinence-only concept is the greatest fraud that anyone could ever imagine. In December of '04, right after President Bush's re-election, the Washington Post reported many young people in federally funded abstinence-only programs have been taught that abortion leads to sterility and suicide, and that half the gay male teens in America have tested positive for HIV, and that touching a person's private parts can lead to pregnancy. The faith-based initiative has diverted tax dollars to proselytizing religion, and that is clearly unconstitutional. There have been efforts at censorship in high schools throughout the United States starting in 1980. And very interestingly, the previous Pope, Benedict, before he became Pope, right before, Ratzinger wrote that the Harry Potter books erode Christianity in the soul of the world's young people. But now, what I want to do is I want to give you the exact quote from Justice Antonin Scalia. And bear this in mind, he needs only one more vote for this to be the law of the land. Luckily, it was a dissenting opinion, because in McCreary County versus ACLU in 2005, we were able to take down 10 Commandment displays from schoolrooms in Kentucky. But Scalia wrote this, and remember, one shift of one vote on the Supreme Court, and what I'm about to read to you will be the law of the land. The principle that government cannot favor religion over irreligion is demonstrably false. This is already a clear statement of the second-class citizenship that we, of course, would suffer. Scalia goes on to write, "It is entirely clear from our nation's historical practices that the Establishment Clause permits the disregard of polytheists, believers in unconcerned deities, just as it permits the disregard of devout atheists." We are one vote away from this becoming the law of the land. Again, for practical purposes, the Constitution says what the Supreme Court says it does. But even more extreme, Justice Clarence Thomas, even in light of the history that I gave you, takes the very, very perverse position that the Establishment Clause, which we now know was meant to ensure the equality of the non-believer, he twists it around completely and says the only purpose of the Establishment Clause was to prevent the federal government from interfering in official state religions. And according to Justice Thomas, it is entirely constitutional for each state to have its own official church. And he is one of the 9 votes on the Supreme Court. So where does this leave us? This leaves us with the need in Senate and presidential elections, though there are many worthy issues, in my view, to make the Supreme Court and the appointment of federal judges the primary issue that guides our vote, because the alternative is for us to be shunted off into second-class citizenship. I remember 1989 hearing a speech by then New York Governor Mario Cuomo, and he said, "It is rank hypocrisy for the religious right to lecture us about limited government and then to turn around and try to use government to tell us, the American people, what God to believe in and how to apply the judgment of that God to our bodies and to our bedrooms." I've given you a lot of information this morning, and even though I am known as one of the more outspoken defenders of atheism, the curious and very, very attractive aspect of a church-state separation presentation is it protects the believer equally with the non-believer. This presentation isn't just meant for us, it's meant for every fair-minded American who wants their neighbor to enjoy the rights of conscience. And above all else, regardless of how the religious right seeks to wrap itself in the mantle of the flag, given the true intent of our founders, those of us, whether we be believers or non-believers, who seek to support and uphold the separation of church and state, are the ultimate American patriots. Thank you. Questions, please. Are the mics on? Okay. Richard, please.
Eddie, thank you very much indeed. I've heard this speech and several others of yours where you make the same very powerful point that the Supreme Court is the supreme thing that matters when you in America vote. You've also shown us the great wisdom of the Founding Fathers and everything that they've said on the separation of church and state. Would you agree that the Founding Fathers, whoever drew up the Constitution, made a disastrous mistake when they gave so much power to the Supreme Court?
Actually, I would say that given what's available politically, it is the least bad they could have done. Because if you imbue a legislative, there has to be a final determination of what the law is. If it is an elected body or a hereditary body, if it is any body that has to face popular accountability, then we lose the number one consideration of the Bill of Rights, which is preventing the tyranny of the minority. So, for instance, if Congress could overrule a Supreme Court opinion, we would have no constitutional law because we would have no Bill of Rights, because it would be pure majority whim. And I know that it's frustrating, but you look at every other country, and even if we don't live up to it, at least on paper, our system is the best for preserving the rights of conscience and free speech rights of unpopular minorities. Now, This, though, I will extend to something else. Remember, I just said that last year Roy Moore was reelected to the Alabama Supreme Court? We need to insulate state court judges from having to face the voters. Because judges, when they rule on constitutional issues, should not have to worry about voter retaliation. The independence of the judiciary means that a final decision on the rights of an unpopular minority cannot result in political reprisal against the judge. Because you can't take a bath with a crocodile in the bathtub. And so every system has its flaws. But lifetime appointment of Supreme Court justice, as frustrating as it is still better than any other alternative. But most of all, we can never let, if you read the Federalist Papers, Hamilton particularly makes this very clear, we cannot allow popular majorities to say ultimately what the Constitution means. I would be very frightened to let a majority of today's Congress determine what the rights of nonbelievers should be. I would be very, very frightened about letting every adult American vote on whether atheists should have equal rights. So, because a constitutional democracy is different from a pure democracy, we need a judiciary that has the final word and that is impervious to popular retaliation. Remember, we church-state separationists and civil libertarians do not believe in pure democracy. We believe in constitutional democracy. We believe there are areas of personal liberty where the will of the majority is irrelevant. Yes, please.
Mr. Tabash, I thank you very much, and I have, I believe, fought somewhat in the trenches along with Mike Newdell on these issues. I have my stripes. What I want to bring up is something quite different. You mentioned in the list of horrors, if we lose. Among them was what the right wing says will be government control of medicine. Right? Unfortunately, there is a problem. When government acts imperiously, and I have identified one particular item, and it is not only me, it has scientific and from the National Institute of Health. I won't go into the details here. It is almost impossible to identify this to be revised. And the reason is that when I say it, we have made it sound, and we have Dr. Dawkins here who invented the word, it comes out as a right-wing meme. Now, I see this as a potential collateral damage in the war that you are so well describing. Because when you're fighting an irrational enemy, you almost have to make your point so strongly that reason and argument is lost. And I wonder if you have any suggestions or response to that.
Well, we don't have to lose argument or reason. What we need to do, remember, church-state separation has an avenue of practical political strategy in that we need to appeal on this issue to fair-minded religious individuals to get them on board to understand their liberties are at stake too. So we don't have to abandon rational argument, but I remember a cartoon in North Carolina when Jesse Helms was one of the senators who was pushing for a prayer in school amendment, and the cartoon was he was invited to a public high school after his prayer amendment became part of the Constitution, where there could be official prayer in public school, and a student was asked to stand up and say the prayer, and the student started out, "Allah be praised," and Helms was saying, "Hold it, that's not what I meant." Anyway, next question, please.
I want to back up for a moment to the subject of popular election of judges and just contribute a fact in support of your position. Every single justice on the Iowa Supreme Court who voted in favor of gay marriage was kicked off the bench by popular election at the very next election, all those who were eligible.
Thank you, Eddie. My name is Dan Blenheim from Connecticut, and I just wanted to mention briefly that I'm very active in the consumer protection movement, and in that community we're having the exact same discussion as we're having here. And one of the things that we talk about in connection with that is the influence of the Federalist Society in forming the federal judiciary and its influence in the Justice Department under Republican administrations. And I was wondering if you might comment on that.
Okay, the Federalist Society was formed initially to support laissez-faire capitalism in the legal system. Now, again, it's very important for those of us who are non-believers, humanists, to learn how to street fight politically. We need to learn the practical aspects of politics, and as I've been saying, and of course as Greta Christina said last night, to learn from the LGBT movement about how to put together actual successful political efforts. One of the things that I've been doing within the Federalist Society, because sometimes I speak and debate before them, is there is a rift that I've tried to exploit in that organization, which is between social conservatives and libertarians. So if you get the libertarians who are more consistent on limited government, then you can turn them against the religious right. But you see, the Federalist Society is just one small aspect of it. What really happens is that even in today's United States Senate, the president is barely able to get a federal judge confirmed. When a federal judge is confirmed, the White House throws a party because even with the current majority, it's rare because the filibuster is still in force. I can tell you, we're meeting here in my home state of California, that there was a very, very capable law professor, University of California at Berkeley, and the president tried to put him on the Ninth Circuit Court of Appeal, federal court of appeal that governs the 9 western states, and the Senate successfully filibustered that, and then Governor Brown was able to put him on the California Supreme Court. But even with today's majority that the president has in the Senate, he's rarely able to get judges through. Yes, please.
I'm a teacher, and this is maybe not as connected, but NCLB, I feel like that's raising a nation of sheep, and that's very much connected with faith-based and the overwhelming conservative religious movement. And so I wanted to know if you have anything to say about NCLB or the education system playing into that system that's going on right now. And then just another Citizens United is horrible, but it's not a connection, but it's part of our justices being bought. I feel like not just Congress, but justices too. So I don't know, either or one of those.
Well, what I would talk about is in the educational system, this is the only thing we can do. In every locale in the United States, we have to be prepared to pounce legally when something religious is infused. We're not going to be able to do it on other issues because there isn't a constitutional mandate. But in any aspect of the educational system, when we see any public, because the First Amendment doesn't restrain private schools, any public institution infusing religion into the curriculum, then we need to act legally.
Yes, what you said earlier about, our method of having a Supreme Court is the least bad thing that they could have chosen. Isn't the fact that it's become so politicized these days, it's almost beyond what our founding fathers intended? In the way that all of us on the left and the right realize our vote for our next president really is a vote for the next Supreme Court justice.
Yes, it is.
therefore it's become political.
However, the reason why it's still the least bad is the bottom line is this. Our objective, and the only way we can ever hope for independent-minded judges, is once they are there, to not be accountable to the voters. And if you take the total history of the Supreme Court, particularly the 50s and the 60s, you see how well it worked. The prayer in school and Bible reading decisions of respectively 62 and 63 would not have come about if the judges had to face political accountability. Most importantly, the school desegregation case of 1954, Brown versus Board of Education, would not have come about. So it's still the least bad, however they get there, once they're there, to make them immune from political pressure. There really is no other way. Yes, Bill.
The word respecting, as used in the First Amendment, is not commonly used, in my lexicon anyway. Could you expand on it? You placed some real significance on it. Could you expand on it and describe it?
Yes, I want to thank you for raising that. If you read the books of constitutional scholar Leonard Levy, he points out that in the late 18th century, respecting meant giving regard to, paying attention to, engaging. So essentially, it meant dealing with, supporting, that you can't even touch upon the subject. No law respecting an establishment of religion means you can't even, it doesn't say no law establishing religion, but no law even respecting an establishment of religion, which means no law impacting religion in any way. And thank you for clarifying that.
Thank you.
Yes. Yeah.
So with the tools that you've given us and with what I hope to download from the website, what other groups should we be reaching out to in your experience that are maybe outside of our circle? Because I think most of us here want to fight for this, but I'm assuming there's other groups that may not 100% agree with us on the religious section, but especially at the local level, who should we be trying to
Any
align with?
mainstream religionists, mainstream Protestants, liberal Catholics, any Jewish organization other than Orthodox, Buddhists, New Age types, anybody with a stake in personal liberty. Any religious believer is an ally on this as long as they meet only one criterion, and that is they don't want government imposing their views on someone else. So that's why I said the church-state separation battle is singularly unique in that we can be allies with anybody who is fair-minded and who wants one's ultimate decision about how to live one's life to not be coerced by the government. Yes, please.
Why is it that state Supreme Court judges are elected as opposed to nominated by the governor, and just the way it works in the federal system? Why is it not at the state level? And is there any possibility of change?
The possibility would have to be in each of the 50 states. But here's the thing. Voters, even though they're really not qualified to judge judicial opinions, will never give up that power. Voters like to be able to say, that judge ruled that that filthy movie could be shown at the Peekaboo Theater, I'm going to vote him out of office. Voters love to do things like that. And to tell the average voter, this is a right you shouldn't have, because judges should be impervious to the popular rejection of their protection of the minority, to do that just wouldn't sell. So it's a battle we have to fight, but our main battle is to make sure that the federal judiciary puts into place decisions that prevent state judges from allowing church-state violations. We have time for one more question. And
Sure, I think mine's fast. We've talked a lot about the importance of insulating judges from popular election. and you also alluded to how hard it is that it can be hard to even get judges in the first place, even if they're not elected but appointed. And I know that there are 60-some vacancies in the federal district courts and another couple dozen or so in the circuit courts of appeals for judges. So it's not only the Supreme Court we should be worrying about, but those lower courts.
Yes,
but
of
how
course.
hard it is and they are basically subject to a popular vote because the Senate's constituents don't care enough to make their senators get some new judges on the benches.
Right,
on
but
those
the thing
lower
is,
court
it's the same
benches.
thing, though. Every federal judge, from district court to Supreme Court, is presidential appointment and Senate confirmation. So the same rules apply. If you make the Supreme Court your main focus of voting for president or Senate, you automatically subsume within that all the lower federal judges because the process is identical.
So who's doing anything about that to make the public care that can get this to become an issue that people
There
are
are
passionate
organizations. We have to do more. Our groups have to do more. It is a very, very, difficult topic. The White House has been publicizing it a lot because they're being stymied. All fair-minded activists have to talk about this. I mean, it's very, very important. I think we can have one more question, and we really need to stop.
Thank you. Appreciate it. What would be your position on a state judge running for election that knows who you are and accepts your donation, knowing that you're an atheist, and then not cashing the check until after the election?
Well, again, in terms of being a practical political activist and having tried to learn the art of political street fighting, given the alternatives, that might not be better, that might not be as bad as not accepting my support at all.
Well,
And quite frankly, given the prejudices of the voters, I couldn't blame that candidate. And so the religious right should teach us something. They got to where they were by starting out with stealth candidates. This is a whole other topic. But I'll just leave you with this, and I think we have to end, and that's this, and this, we need to stop because we're over the time, and that is this. We must learn what our religious right-wing opponents have learned, how to be effective in the real world of guts and blood political infighting. I think we're out of time. Sorry. Thank you, everybody.